Good afternoon. We're now going to segue to a panel discussion about many of the issues that our honor has just so eloquently synthesized. My name is Marcellus McRae. I'm going to be the moderator of this panel. I'm a litigation partner and white-collar criminal defense partner at the law firm of Gibson, Dunn, and Crutcher in Los Angeles. I'm also a member of the Board of Advocates of Human Rights First. Let me start with Ms. Barba. Ms. Barba is the director of the ABA Immigration Justice Project. I'll now move down to Davina Chen, and please, obviously, if there's more that you want to talk about relative to your background, don't let my
two sentences work
restrain you. Is an attorney with the Office of the Federal Public Defender since 1999, and Ms. Inlender, if I butchered your name, please correct me. As a staff attorney and former Equal Justice Works Fellow in the Immigrants' Rights Project at Public Counsel, of which, by the way, I'm a member of the Board of Directors, so nice to see you as well. And with your name, I'm going to be a little bit more cautious. Is it?
Pinheiro.
Pinheiro. Ms. Pinheiro is the lead attorney for the Adults Program at the Esperanza Immigrant Rights Project. And with that, let me start off by saying that we did get quite a good summary of the salient points that we wanted to talk about here. First of all, recognizing the need for effective counsel, obviously a very critical issue, the paucity of resources there. What are the challenges as far as getting people effective counsel and having counsel? What are some of the gaps that exist in the system? And again, Her Honor has touched on those geographic constraints, constraints as far as, again, funding and so forth. What are some of the workarounds that people have in their day-to-day practice, and that's recognizing the work that all of you do. And finally, on a prospective basis, what are some of the solutions? So with that being said, I mean, it may make some sense to sort of flesh out a little bit more some of the other constraints, quite frankly, and challenges in terms of effective legal representation. And if anybody wants to jump in on that and sort of flesh that out a little bit more, please feel free.
Sure. Do you want us to talk each about our projects a bit?
Sure.
What it is that we do?
Sure. If we can weave that within the congruence of the topic, that's fine.
Sure. Well, obviously, Judge McRae has done a great job of explaining how the IJP got started and why it got started. And part of it was because of the constraints that we do have in immigration court, not having any counsel at all. So to that extent, we have both the legal orientation program and the pro bono component to our program. So it's two-pronged, and we work out of the CCA Detention Center in Otay Mesa, which is a contract facility. Just to tell you a little bit about it, it is a private-run facility, and it does look like a jail or a prison, whichever you would like to call it, it's both. So we serve about 700 people at a time, try to see everyone through the Know Your Rights presentations that we do 2 to 3 times a week. And in that, try as quickly as possible to get everyone educated about their rights and what it is that is going to happen once they get to immigration court. Now that's just half an hour that they get from us. That does not replace an attorney. So what we do is then talk to them individually, and through our program, try and match them up with volunteer attorneys. Of course, we can't represent everyone that comes through our system, so we try to do the best we can. And we're dealing with many constraints, the large population that we see, the fact that we're only there a very limited amount of time, and the fact that we only have a staff of 3 people.
Wow. I was reading somewhere about another issue in addition to the limited numbers, the geographic dispersion. There's also an increasing use of video conferencing, apparently, not only with respect to the administrative hearings, but also in terms of initial sort of debriefing and interviews of clients. Does anyone share a concern about how that may underserve the need for representation and what particular problems that poses?
Well, Erika's about to run into that in big measure in Atalanta, so she might want to speak to that, but I'll say we don't have that problem. I run a legal orientation program that's not funded by EOIR, so I actually just launched it through my Equal Justice Works Fellowship about 4 years ago, and I think there are some advantages and disadvantages to that, and we can speak to that in question and answer if you're curious, but At the facility that I run, there are video courts right now, but but we can actually see people one-on-one for counsel consults. I'm not sure what it's going to be like at Adelanto.
So right now we're in a transition phase in Los Angeles right now. Originally, our legal orientation program worked at the Loma Detention Facility, which was run by the LA County Sheriffs. And now that facility is closing, we're moving to Adelanto, which is run by the Geo Group. It's only video conferencing for the courts. And so before Loma had its own judges, its own court system on site at the facility. Now it's 100% video conferencing. So the problems that I've seen in representing individuals, first of all, you don't have a chance to confer with your client before the hearing. So any last minute things that you see going through the file, there's just no way really to communicate with your client. There's no way for any last minute preparation to take place. And the quality, honestly, isn't that great a lot of the time. So can't see the person, maybe can't hear everything that they're saying. They can't really see or hear what's going on in the court sometimes. It's almost like being on a cell phone. There's a lot of breaking up happening. And documents, I mean, a lot of, especially unrepresented people, they don't know that they have a filing deadline. They don't know that they have to give documents to the court ahead of time. They show up with a huge stack of documents to their hearing, and it's a very rudimentary fax system that goes between the court and the video courtroom that's located at the facility. So it's not ideal. The judges thus far have shown enormous resistance to actually physically being placed up at this new facility. And so it looks like the video conferencing is just going to continue and grow in Los Angeles for the time being.
So you're with the judge and the client is in the jail?
Everyone, yes,
everyone is
in the courtroom except for the client.
I've been asked to have people speak into the microphones as
sorry.
much as possible, and then we need to.
Okay.
I mean, what's interesting about Your Honor's comments, you talked about representation having sort of a dual aspect. One is not having counsel at all. The other is not having effective counsel. And it's interesting that there's actually a common denominator here, at least from sort of a due process construct, that as an ancillary point, your ability to have effective counsel may be compromised if you obviously can't meet with them or if you can't share documents. And the fact that the quality of the hearing itself obviously is intertwined with the representation. And I'm just sort of curious, do you see this effort, and I'm sort of moving around a little bit in terms of having prospective solutions, as people approaching these issues piecemeal or sort of taking it on all at once, sort of basic, sort of Sixth Amendment, 14th Amendment type concepts in an integrated basis?
Well, and let me just say one of the most striking differences here when you talk about can we compare detention situations in the criminal arena with the civil is that there's no right to counsel. And that obviously is no constitutional right. There is, of course, a right within the immigration procedures to a counsel of your choosing, which is kind of an interesting turn of phrase. You can choose a counsel, you just might not be able to afford them, or you might not be able to get them. But what we do see is that we've had cases on constitutional grounds where there were imperfections in the hearing. I mean, one of the most basic imperfections is the record of the hearing. And leaving aside translation issues, which are often an issue, sometimes we're talking about just basic quality. So you all have been to immigration court. If you took the average American lawyer and you took them down there and you showed them in some cases a reel-to-reel tape recorder, you know, they would be horrified to think that is the court reporter, so to speak, for reporting. So we've seen cases, you know, and I don't want to speak moving forward on hypothetical cases, except to say that we have seen a number of constitutional challenges to procedures, because once you get in a proceeding, then there are some fundamental rights and issues that need to be adhered to.
Yeah, it's just...
And so it's an interesting point you raised.
And let me just ask if others have, in their own practice, experiences that speak to some of the challenges. I think we've covered a fair number of them, but if there any ones that are particularly compelling or unique, we may want to vet here. Please speak up.
I know we talked earlier about the dangers of sort of separating out particular populations for special treatment, but I do think that there are significant challenges among certain more vulnerable populations. Anybody who's sitting in a detention center without the right to get out, without basic access to phones or family or counsel is obviously in a vulnerable position, but there are certain populations that we see in our detention work that are sort of even more at risk. And two of the populations that I've spent a lot of time working with over the past 4 years in my work in the local detention centers is one, the LGBT community, and two, people with serious mental health issues. And the first group, and I think the responses to the challenges are different, and I think the responses need to be different at some level, or can be addressed differently. Their representation needs can be. So with the LGBT community and at the Santa Ana jail, we actually have sort of a national model facility, or what ICE is calling a national model facility. There's a unit now that is specifically dedicated to only gay and transgender, male to female transgender detainees. It has 64 beds. They're usually not all full, but now they're getting pretty close. Usually it's at least 40 detainees, and they often have been seriously traumatized in their home countries, have suffered severe past persecution and torture, and often have been in the United States for quite a period of time, having fled when they were younger due to sexual abuse and trauma and other things that have happened. Many of them have prior deportation orders because they never had counsel before, so they went through often the criminal and immigration system for minor offenses. Often we see loitering for prostitution or offense that lands them in the immigration system. They don't know they have any rights, they don't think that they do, and they agree to take a deport without ever seeing an attorney, without having a right to one. They get deported, something terrible happens in their home country. We just had this with a young man, 19 years old, had never been in Mexico, was deported without ever talking to counsel, and 2 weeks after he was deported in Tijuana, was picked up by the Mexican police. He had long hair and was wearing tight jeans. They beat him extraordinarily severely, stomped on his testicles, and told him that they didn't want gay people in Mexico and he should go back to the United States, which he did quite promptly as soon as he could, to protect himself. This time we did find counsel for him. We were able to get pro bono counsel, and earlier this year he was granted relief under the Convention Against Torture. So the difference between having had access to counsel for him and not meant the difference between being sent back to a country where he was tortured or not. And that's somebody who we were able to find representation through, it wasn't Gibson and Dunn, but through a large national law firm. That's the pro bono model that Judge McEwen referred to, that Veronica uses. And I think for certain vulnerable populations, that model can and does work. For the people with mental health issues, it's harder, right? It's harder to find pro bono counsel. These are people who don't understand their proceedings, don't understand why they're there, sometimes can't communicate effectively with counsel. And the response there has to be different. Maybe other people want to speak to other vulnerable populations before I go into the mental health, because that's a whole other issue. Go for it.
Yeah, it's kind of counterintuitive. I mean, it seems like those would be the most vulnerable, and yet you say that may be the greatest challenge as far as getting pro bono representation. I understand the difficulties in communication, but isn't the need more acute?
The need is very acute, but the resources are very, very intensive. First, just identifying the people. So let me tell you the story of my first client with a serious mental disability, and which sort of launched my work into this. His name is Jose Antonio Franco Gonzalez. He was detained first at Miraloma, then at San Pedro, then in Santa Ana, and eventually in San Diego over the course of 5 years. He had initially removal proceedings in 2005 after he was transferred from the criminal justice system. He suffers from moderate mental retardation, has the cognitive abilities of a young child. In that case, a judge recognized that he was unable to represent himself, but there was no pro bono counsel, at the facility that he was at, and so the judge administratively closed the case. So didn't end it, but said we can't move forward unless this person gets an attorney. That was in June of 2005, and then he sat for year after year after year with no bond hearing, no removal proceeding. He sat in detention in Santa Ana in the very facility that I was for a year until I met him doing a legal orientation program at, without being identified to me or to anybody else. He couldn't put his name on the list. He couldn't write to join the program. So just identifying the people that need that help is sometimes really, really difficult. Once they are identified, you know, Mr. Franco, again, 5 years with no process. And so, you know, and eventually we filed a habeas petition. We were able to get him out of detention, though his removal proceedings continue, but his story is not unique in the system. There are a lot of people, just as the people earlier today spoke about the criminal justice system and the immigration detention system. There are a disproportionate number of people who suffer from serious mental disabilities, who are stuck in the system without identification, without attorneys. And so we have worked closely with Akilan, who's here from the ACLU, and many other advocates to change, to amend our complaint in the habeas petition and file a class action lawsuit on behalf of people with serious mental disabilities, seeking, one, to create a real identification and evaluation system to determine who people are who may be incompetent to represent themselves. When somebody is found incompetent, to get them an appointed attorney, a government-appointed attorney, and we've worked with Davina's office at the Federal Public Defender's Office a little bit to talk about what that system might look like, and then to get bond hearings at 6 months so that people don't get lost like Jose was for years and years and years without any access to the courts. So the response there, and why I think a pro bono system won't work for this population, is because they're complicated cases. They often have complex criminal histories, complex immigration histories. Many pro bono counsel are coming from excellent large law firms, but they're not versed in the criminal and immigration law, and we're talking about the most complex of the most complex cases. So it's a lot to throw a pro bono firm behind, and again, the criminal histories often make it less politically palatable to place the cases.
Are there any strategic partnerships between very well experienced lawyers like yourselves to accelerate that track for large law firm lawyers?
To accelerate the
learning curve.
The learning curve. I mean, we do. I think we all have sort of different models. The way that public counsel does it is through really one-on-one mentoring. We don't often do the large-scale trainings in our work because we found that sometimes they don't always translate into taking direct representation of cases, and that's sort of our primary concern. So we do a lot of direct mentoring, but frankly, the numbers are really high, right? We're not talking about, 1, 2, 3 cases. If we were, that's the judges, some of the immigration judges, frankly, have been quite upset by our lawsuit and say, well, you're spending all this time, filing this class action, why aren't you just representing them? And the fact is, we don't have the resources to represent the high numbers of people that need our help in the system. So I think there are ways, and we've done it through working with pro bono law firms to take on individual cases, but I think as a systemic solution, at least for this population, maybe for the broader population, but certainly for this population, I think pro bono representation is not going to be the be-all and end-all answer.
I'm sorry, go ahead.
I think that one of the things that Talia is talking about is that these clients are extremely difficult to deal with, and they're extremely difficult to communicate with. And so I think that's one of the reasons why Ahilan of the ACLU and Talia came to our office, because as public defenders, we do deal with people who have a lot of mental illness issues, that have competency issues, and who have complicated criminal and immigration histories. And our founding document is the Criminal Justice Act, and one of part of what I was going to talk about is all the different types of cases that we're allowed to work on. And when they wrote the Criminal Justice Act, they added a section which is sort of like when there's a due process right and counsel is required by federal law. And so part of what they're attempting to do is to create a federal right to counsel in those cases. And if there's a federal right to counsel in those cases, then whether it be the Criminal Justice Act or something like the Criminal Justice Act, counsel will be required, and we won't have, I mean, the pro bono partnerships are fabulous.
Yep.
But to have trained professionals who are expert in immigration law, criminal law, and who have experience dealing with these mental health populations. And so I know that in that class action, my employer, the Federal Public Defender, did submit a declaration saying that if the court were to find such a right, and that counsel would be required to be appointed, that our office would be available to those kinds of appointments. But which brings us to the next question, which is, can we be competent, right? Because we are criminal defense lawyers, right? Can we be competent in these proceedings? And I think that we can't do that unless all these people who have offered their services create a system in which they train us to do that, because we are not criminal defense lawyers.
It's a very interesting question because, you know, it underscores a couple of points, and one of which is, it seems like as a paradigmatic shift, at least in terms of thinking, until this moves from a conversation about suggestions to rights, you're not going to see measurable change. That's one thing. And I'm actually a former federal prosecutor. I was an AUSA in Los Angeles, and I was going to ask you, since you're with the Defender's Office, you know, the visibility I think that most federal prosecutors have into cases, and of course, being in the Central District of California, there's a fair number, at least at that time, of cases with immigration angles to them, is pretty much done at the point of the criminal prosecution. And do you think that people that you come across, when you represent them in a criminal defense capacity, are perhaps better served or captured you know, in the net and don't fall through the cracks because you know that they're going to have an immigration issue? And do you facilitate that and transition those people to counsel? I've always been curious about that. How does that work?
We do, absolutely. I mean, part of what I wanted to talk about is that I'm not a policy person. I don't, you know, it's hard for me to think about prioritizing rights and needs, whatever. You put a case in front of me and I work it, right? And I work it 150%. I pick someone up on the day that they're arrested and I work it. So the question becomes really, what does 150% mean in terms of what it is that I'm doing for my clients who have immigration consequences? And second, how do you get that case in front of me? So there's really straightforward ways in which we can talk about what that 150% means, and that's in those cases that you all might not have noticed had immigration consequences until we brought that to your attention. So the immigration cases are obvious, right? But there are also the fraud cases, the drug cases, all those cases in which we have people who are either undocumented or lawful permanent residents who can either be deported or lose their permanent residency. And so, especially after Talia was decided, we really doubled down on our efforts not only to understand the immigration consequences ourselves, but to bring those consequences to the attention of the U.S. Attorney's Office to see if we could negotiate dispositions. And on that, I wanted to give a shout out to Brianna and Graciela, who are in the audience, because Brianna is our immigration specialist. She's an AFPD, but she's our immigration specialist in our office, and Graciela is the immigration specialist at the LA County PD's office, because this stuff is complicated. I mean, you have to read the slips every single day in the Ninth Circuit, and for those of us who work in the federal system, we're not even sure that our clients are going to be in the Ninth Circuit when they face deportation proceedings, because most of them are probably going to be transported elsewhere, especially people with detainers. They end up in Texas, especially they end up. So it's really complicated. So we have people that we've designated, you know, to help us with those procedures. But then there's like stuff that happens after that. I mean, what about when we make a mistake? We like to try to catch our own mistakes and then allow our Criminal Justice Act representation carry on to the next step. So I'm an appeals attorney, and I recently caught a case in which a client was allowed to plead guilty to a fraud for $1 million, and she was an LPR, registered nurse, 5 U.S. citizen children, and I had a sinking feeling that her attorney had not advised her that this was an aggravated felony that would result in her automatic and non-discretionary deportation. So I spoke with her, and that turned out to be true, and I spoke with the attorney, and that turned out to be true. And this is one of those cases where it's so much better for us to catch our own mistakes, because I brought it to the assistant U.S. attorney who had handled the case's attention. And she agreed that if anyone had raised the issue with her, she would have allowed this defendant to plead to something that would not have resulted in her automatic deportation. So it's taken a year, but her plea to the fraud has been vacated, and she's pled guilty to a different offense, paying remunerations. And that might be a crime involving moral turpitude. I'm not sure yet, but it's not an aggravated felony. So we do that part. The real question I think you're asking is, do we do the next step after that?
Right.
And we try our hardest. I mean, the cases in which we do the next step after that mostly are in illegal reentry cases. I think most of you are familiar with illegal reentry cases, but in order to prove the crime of being in or being found in the country after having been deported is that the prior deportation have been consistent with due process. So our clients who were previously deported and there was nothing wrong with their deportation are probably just going to be reinstated unless they have like a CAT claim or something like that. But for our clients who are able to find a problem, a due process problem with their prior deportation, if we can win a dismissal either by the judge or by the U.S. Attorney's Office voluntarily dismissing, we have on occasion, and we would like to do it more, gone into immigration court and moved to reopen their proceedings so that they can get status. And we've had help by everyone at this table, a lot of people in this room, in helping, either doing the case for us or helping us to do those cases. So we view that as part of our representation, and the Criminal Justice Act allows any services that are ancillary to our primary representation. So we do that. Our next step, I think, I recently won a case in the Ninth Circuit where a client's 1326 was reversed because the record of his alienage was a so-called birth certificate from the Philippines, which violated his Confrontation Clause rights. With the permission of my employer, I then filed a writ of error quorum nobis in the Eastern District of Missouri, which is where a prior conviction he had for impersonating a U.S. citizen came from. And immigration had traded his prior conviction for impersonating a U.S. citizen as conclusive proof of his alienage, and has stopped him from attempting to prove his status as a U.S. citizen. And so I filed a writ of error quorum nobis, and the judge in that case just granted a stay of removal in his case. So there are creative ways in which we ourselves can do the immigration work with support of our immigration colleagues. The problem is, we try to refer as many cases as we can to them, but their resources are very, very slim. I feel so fortunate being here today that, frankly, I am a federal employee. There's a Sixth Amendment, there's Gideon, there's a Criminal Justice Act. There's a constitutional right for my clients to have my counsel, and as far as I can extend that, I will within the bounds of the law. And then we will make our best effort to refer that where we can't.
But before we move on, I want to ask you a question about the anecdote that you relayed where you caught the mistake.
Yes.
It's curious because I'm wondering, maybe you've already done this, is your office dialoguing with the U.S. Attorney's Office to see that on both the intake side or disposition side for the federal public defender, as well as the disposition side for the U.S. Attorney's Office, that either in a plea agreement or in some sort of checklist, someone has to affirm that they've considered whether or not there is an alternative to something that would result in deportation?
I wish that you would tell them that they should be receptive to that. It's actually quite the opposite. They have, in their adhesion contract plea agreements, they have inserted a section on the advisal of rights that this conviction may, not will, have immigration consequences, and the judge is not qualified to advise you if it does, and your attorney may not be able to. And so not only have they not entered a process in which we're all trying to work together, but it's sort of asking our clients to waive the right to have that, what we know Padilla tells us, is the right to effective assistance of counsel. And boy, have we negotiated to get that language out of the plea agreement, but they're not budging.
As a segue, we're talking about resources, and maybe we can move to start talking about potential solutions, but sort of a common strand that you hear in these discussions are also fiscal constraints. Where's the money going to come from? And one of the most compelling things that I was reading in preparing for this panel was the cost of detaining someone on a daily basis versus the cost of alternative arrangements like, ankle bracelets, detections, that sort of thing. And if you think about it in terms of dollars and cents, the more that these alternatives, like the one that you and I were just talking about, for example, just to place it on someone's radar, that you can significantly depopulate the group that goes to detention by seeing if there's a palatable alternative. You could be talking about enormous returns on investment without offense to public policy or other types of considerations. And I'm just curious as to whether the rest of the panel thinks that that approach to this issue, there's the human rights approach, there's the civil rights approach, but often in government, things don't get moved unless you monetize them and can explain that it's actually a more efficient investment to do that. Is that something that you're shaking your head?
I think they have a lot of money. There's a lot of money in detention. People are making a lot of money off of detention. The cities are making a lot of money off of detention. The counties, Orange County, they opened they had two intergovernmental service agency agreement facilities in Orange County. Those kept Orange County jails afloat until the realignment came through, right? And then, of course, we already talked earlier about the privatization of detention facilities. There's a lot of money in this detention system, and there are a lot, and I think there's actually, the incentives are skewed, right? The incentives are towards more detention because there's a big lobby for it, and I think we should be out there and we should be pushing the money argument, and we should show people who are not on the lobbying side, we should be talking to citizens and taxpayers about what it means to have their money going to this. But I think right now, if you talk to ICE about it, or if you talk, I think that they don't have a lot of incentive to move. They want those numbers up because they want their budgets to be renewed at higher rates. And I've heard them say that in meetings.
We're talking about the federal government, right?
Yeah.
We're talking about the federal government that's allowed to run a deficit. So the incentives don't work the same way that in state and counties where they have to balance their budget. And then the budget pockets are so divided. So maybe if the U.S. Attorney's Office believed that its budget would be affected, right, by how many people ended up in immigration detention after, that might make a difference. But it doesn't affect the U.S. Attorney's Office budget, right? It affects a different budget. If we could somehow get, Barack Obama to sit down and do all the budgets himself, he would probably see, right, that, oh, wow, if the U.S. Attorney's Office is raising its stats this way, it causes this huge, gigantic detention problem over here. But that's,
But here's what it does help. It sort of just negates their ability to say, oh, it costs so much money to get counsel. It costs so much money to do all this stuff. It costs far less, we think, to get counsel than it does to be detaining people at the high rates and for the long lengths of time that they're detaining people.
The important thing to remember is that the statute says, you have a choice of counsel at no expense to the government. So, Veronica and I work on federally funded legal orientation programs. We are not allowed to use that money to represent anyone. And so even if the budget were to increase and, they wanted to provide counsel to all these people, they would have to make a change in the law. And now it's interesting, just going back to the vulnerable population question, I think we're forgetting that there's a lot of children detained by ICE as well. And in the past 2 years, despite the fact that the statute says that the federal government cannot pay for counsel, through our own legal orientation programs in the children's detention centers, they have allowed us to provide representation to children, and we've managed to provide representation to every single child in detention in the Los Angeles area. So it's not completely out of bounds. It's not impossible to do. As long as the political will is there, I think they'll find the money. But it's also a numbers issue, because right now the way that the legal orientation programs are set up, at least for us, we talked to 7,000 people last year with 3 attorneys. And I think the numbers are probably similar for your programs. So yes, it would be a huge infusion of resources. Like Talia said, I don't think the detention numbers are going to come down. If anything, they're going to go up. So, there's just a lot to be worked out there, but the statute, as it reads today, does not allow for the government to provide counsel to these people.
But they've interpreted it as not barring that either, right?
Exactly.
So I'm not
sure the children.
We can
yeah.
So if we can go into court under some other mandate, then we're allowed to. Or if they're in federal court, so if it's a case where there's a 2241 or they have to take care of their post-conviction, their previous convictions on a 2255 or 2254, the Criminal Justice Act does allow discretionary appointment of counsel in all of those cases. That is how we represented the indefinite, or I guess they're called prolonged detainees cases. And I wanted to remind you all that that kind of representation remains available. If you have a client who needs to file a 2241, you can talk to our office and we can seek appointment on that case because it's in federal court, and that gives us, gives the magistrate or the court the right to discretionarily appoint. If you have somebody, an immigrant who's in detention, who's indigent, and the issues are complicated, there's a high chance that there will be a discretionary appointment. If our office is behind it, and we've said that we think that it's something that the person needs representation. So that's another sort of avenue where we can kind of get around this no government lawyers.
Yeah. You're familiar, obviously, with the panels, the indigent defense panels.
Yes.
I'm curious, if there's a change in the law that allows access to federal monies to do that, I would assume then that you'd have a whole
new panel.
phalanx of
a different panel. It would be a different panel, right? It would not be the panel that was selected based on their experience and their desire to represent criminals in federal proceedings. It would be the, you know, whatever, if it's, this is the mentally incompetent, detained immigration, that it would be that panel.
Right. Well, we've talked about a lot of the constraints and the challenges, some of the workarounds, and clearly I think from that discussion some of the gaps that obviously exist in the system. There are probably two ways to look at solutions, at least. There's long-term and short-term, and I suppose there's the aspirational and the pragmatic on those plans. And with that, why don't we segue to that? I mean, in terms of those that are really in the trenches, what are your thoughts? And maybe, Talia, we can start with you as far as what are the most practical or immediate solutions to at least some, if not all, of these issues?
Well, I mean, I think...
Not to put you on the spot.
I can solve all of these problems. No worries. I mean, I think we're working on it. I mean, I think, like I said, I think the short-term solution, which is, you know, really a Band-Aid, but is a short-term solution, is a pro bono representation model for the people who we can get pro bono representation for, and just with the understanding that that is an extremely limited piece, but that probably has to continue until we can really push the right to counsel efforts forward. We've started, the Franco Gonzalez lawsuit is the first class action lawsuit in the country that seeks a right to counsel on behalf of a group of immigrants. So far we've been lucky and had really great success. We've won several preliminary injunction motions requiring the government to either appoint counsel or to terminate the cases. They've done a little bit of both. And we now have, we moved for summary judgment. That motion is now submitted and it's pending, so we're awaiting the results on that. So I do think, you know, we need to do these sort of Band-Aid solutions that work for a lot of individuals, the pro bono representation, the direct representation through our offices, while we're fighting for a broader right to counsel. I think more collaboration with the Federal Public Defender's Office is a really exciting opportunity for us, both because our clients can get really quality representation, but I also think, and we can, you know, get help with our work, but I also think it's a really important cultural shift for the immigration courts. So, you know, the immigration courts are just not used to seeing lawyers. And often as Judge McEwen said, they're not used to seeing good lawyers very often. And so the more good lawyers who get the law, who care about procedures, who understand what a fair hearing should look like and believe that there's an entitlement to one, I think the more that we can infuse the immigration court system with those types of people, the better the system is going to be as a whole. So I do think, I know I'm excited about the idea of having more federal public defenders in the system and having pro bono attorneys who are really committed to doing the work while we fight for a broader right to counsel.
Anyone else?
Well, I just wanted to say that even we're in Los Angeles, there are many immigrant rights organizations. Amongst all of us and other organizations, we try to see as many detainees as possible, at least give them information about their options. And even in Los Angeles, there's a detention facility that gets 0 attorneys. Yeah. You know, and that's a higher security facility. There are people with mental health issues there. And this is in a major metropolitan area with a lot of resources and detention centers that are relatively close to where the attorneys are located. And so if you look, the programs only cover about a quarter of detained population.
There's only 26 sites.
Right. So there are thousands of people who never even see a lawyer, period. And so I think we really need to start there, at least making sure that detainees have access to information, because right now they're just being shoved through the immigration court systems without even knowing that they have a defense against deportation, that they have any rights. They're not given this information. Certainly ICE isn't giving them this information, I can tell you that. And so I think the first step is really expanding access to information for the detainees. And now whether we want to move toward a model like we have with the children's program, where you do have immigration attorneys who specialize in these types of removal cases, being paid by the government to represent people, now I think that would be the ideal solution. But we're so far away from that for the adult population that I think, you know, at least going toward the first step of having access to information is really important.
And I also wanted to say, Judge McEwen touched upon the quality of the representation, and I know that all of our offices probably have dealt with cases that have had representation that we then have to go and fix and clean up because a person has been sitting for so long filing frivolous appeals or having been represented by someone that really didn't know what they were doing. So I think the more that the immigration judges can take a proactive approach of reporting, well, not reporting, but, you know, doing the best that they can and not letting this continue, and us as lawyers as well, is another step that we can take.
Davina?
And as an attorney who represents a teeny little portion of these people, I think that I wanted to remind you all that you can continue to train the criminal defense attorneys, either at the county level, the federal level, private criminal defense attorneys, to spot issues and to actually represent our clients well. We are, for a lot of your crim im cases, we are the one attorney they've ever seen. And we are often, we were joking at lunch, we're always the villain in all these stories. And then the public defender pled them to this, and they didn't tell them this. So we don't want to be the villains. We want to be the ones who understand where people have relief available, either they continue to have relief available now, how we can plead them in such a way that they won't face immigration consequences. Brianna, who organizes our brown bags on immigration, recently had Talia's colleague Judy London at Public Counsel come to speak to us about gang-based asylum, CAT, and withholding claims. And I really learned a lot. I learned a lot in everything that Brianna brings us, but I really learned a lot about how things operate on the ground, because as attorneys, as federal public defenders, we learn almost everything we know about immigration law from reading the cases, and those are all the bad cases, right? Those are all the cases where people lost or where the Ninth Circuit is denying relief. And so I was able to learn, oh wow, people are winning gang-based claims. They're just winning them as family-based claims or religion-based claims, or, you know, if the guy looks a lot better, they find other ways for him to win a CAT claim. And that's very, very encouraging for us, because we just read the slips and they're all bad. And so we see so many people who are going to be deported, specifically, for instance, to El Salvador, who do tell us that they fear that they will be tortured the moment they get off the plane. And if you read the slips, it sounds like, oh, well, that's just too bad. And so to have you guys continually come and train us about how things are actually happening in immigration court as opposed to what we read in the slips is totally invaluable for some of those clients that may be the only time they see the lawyer is when they see us.
Well, I think we should probably end the way we began, and I was going to turn this over to Veronica for some concluding comments.
Thank you, everybody, for your comments. You see it in the trenches, you see it day in and day out. I have just a few remarks. First, I think I certainly was naive in looking at pro bono representation, thinking that you could just enlist, armies of hundreds of people, and I was quickly disabused of that because, thousands of high-quality pro bono attorneys running around doesn't necessarily make effective representation, and it takes a certain amount of administrative staff. And I see Veronica shaking her head and the others, so we can't just let attorneys run wild, so to speak. It turns out we all have to be supervised, and that of course was stunning to me, because one person can only supervise so many, and you don't want to get the pro bono and other projects in a situation where they're not providing effective representation. But it does seem to me that some of those kind of investments are very worthwhile, whether it's the Know Your Rights projects that actually cover thousands of people for a very small upfront staff investment, or whether it's a handful of attorneys that can manage hundreds of others. But again, it can't be done without some resources. I think Davina touched on really a critical issue, and that is this intersection between immigration law and criminal law. We see it all the time, but I think there are some concrete things that could be done there with respect to training of judges as well. So it may be that plea agreements and various other cases may say that, you know, the judge doesn't have the obligation to do certain things. But I think many times, and I'm talking both about federal and state courts, the judges may not really understand the intersection. And so that to me seems to be a ripe area through the administrative offices of the state courts as well, to look at some concrete training programs. We've done them in the Ninth Circuit. I think everybody there, all the judges, were very impressed with these programs where we brought in representatives from the federal defender and the U.S. attorney. But you know, to a certain degree, we have a family that within the federal system we can reach out to. That's not necessarily true in the state system. So we have a little bit more of a structural advantage, I think. In the end, I also want to mention, of course, that one of the things we're faced with were a series of jurisdiction stripping statutes where Congress affirmatively did not want certain issues in federal court. And so we've had to parse through all of those to see exactly what those statutes meant. The one thing I think everybody can agree on, Congress and others included, is that if there is a colorable constitutional claim, that will find a home, at least for a hearing in federal court. So those are the kind of claims that we continue to see are colorable constitutional claims. And finally, in listening to this, as you might imagine, not only I have been, but all of the panelists and others have been on these panels and at these meetings many times. And the issues come down to two: money and right to counsel. And that is repeated again and again. You know, none of us, or most of us, are not policymakers or legislators, let alone masters of the budget, where we can dole out money however it might be. So that's not necessarily an effective course. And nor are we necessarily, you know, again, Congress hasn't granted a statutory right in this regard. So it seems to me that in some respects, there could be some stepping back to look at this a little bit differently. And that is, as lawyers, and I think most people here are either lawyers or associated within some law-related institution. As lawyers, you know, lawyers are very analytical, lawyers are very smart, but we were trained in a certain way and we look at things in a certain way. It seems to me that this question is kind of ripe for another look by somebody who's not one of us, who's not a lawyer. Whether funded through a foundation or something else, somebody to come in from the outside and say, if I had this system, and if I had these two big problems, what are some of the things one might do? One, to attack the information gap that was mentioned here. Two, how might one attack the structural gap that I think Talia mentioned, for example, a client or an individual who can go unheard from for year after year after year. I mean, that's not a question of lack of representation, that's a lack of, at least initially, the person didn't even get like an asterisk next to their name. So that's a structural question. What are some of the institutional issues that could be changed even within the present framework? And then finally, are there some other innovative ways we ought to look at counsel? So again, I think it's that these discussions that are being sponsored here by Human Rights First are enormously helpful for all of us to start thinking innovatively, but also a chance for us to say, could somebody else take a look at this besides us and give us some more and different solutions?
We will now segue to question and answers, if there are any questions, and please, feel free.
I have a question.
Ms. Epstein.
Thank you very much. Is this on, folks? This has been an incredibly valuable discussion to think about sort of broader systemic change that would put potentially increase access to counsel for immigrants and access to quality legal counsel. I'm curious from our legal service providers on the panel to hear kind of the nuts and bolts. Which facilities are you serving? Which facilities are not getting served? How many times a week are you able to get there? Do you have the resources to get there? And where are the big gaps? I know that you're all, I mean, I spoke to each of you in preparation for this conversation, and I know you all are working incredibly hard, but as I mentioned earlier, there's 3,000 ICE detainees in Southern California. You're 3 people plus a few other staff members, so I'd like to hear a bit about that.
I'm going to start with Orange County, since we're in Orange County. When I started working in Orange County 4 years ago, I started a program at the Santa Ana City Jail. There are about 200 ICE detainees there, and it was the only facility in Orange County that was housing ICE detainees. So they were all at least getting seen or having the opportunity to get seen by an attorney. In the past 2 years, they've opened 2 new facilities, one at the Music Detention Center, which is down the street in Irvine, and the other is at the Theo Lacy facility in Orange. Each of those have capacity between 300 and 400 ICE detainees. Public Counsel, along with Esperanza, Crecen, and Public Law Center are doing a monthly legal orientation program at the music facility, so we're there once a month. I'm at Santa Ana once a week on Tuesdays, and as Erika mentioned before, there is no legal service provider right now that's serving the Theo Lacy facility on a regular basis, so I will sometimes run down to be able to go out, but there's no systematic provision of a legal orientation program or any other access to counsel at the Theo Lacy facility right now.
We are at the Otay Mesa Detention Center in Otay Mesa, San Diego, which is pretty much near the border. We have a population of around 700. It's a CCA facility, and it also houses U.S. Marshals. But I don't include those in the population. We're there around 3 times a week, hoping to see everyone there. We provide also a Know Your Rights presentation to the non-detained population, which is a little bit different, once a week, to those people that go to the San Diego Immigration Court in downtown San Diego. One facility that is not served, which is 2 hours from us, is El Centro. It's another service processing center, and we, I think, every week receive letters, a ton of letters from them. Yeah, I think everyone receives letters from them because they just have no one that goes there, and there are a very limited amount of private attorneys who will even go out there and serve. So we get lucky sometimes, and someone's transferred from that facility to San Diego to the Otay Mesa Detention Center, but unless they have a medical condition, they're probably not going to be transferred.
So as I mentioned, we were working at the Miraloma Detention Facility, which is located in Lancaster. There, at its peak, there were 1,400 people there, and we go every single day, well, 5 days a week, to do the legal orientation program there. Now they've been drawing down that population over the past year. Adelanto just opened, I think it was a year ago, and that has a maximum capacity of 1,300 detainees. They're almost there right now. Over the past year, there have been no lawyers going out there at all, no access to counsel, and just last week we found out that Miraloma is closing and our contract is being switched to Adelanto, so we will be providing services there. So right now it looks like El Centro, which I'm not sure how many people are there. You know,
I think that's somewhere in the materials.
A couple hundred at least. So.
Can I ask you a question, Veronica? Sure. You work with the pro bono attorneys, right? How do you decide? Does every client who wants an attorney get an attorney, or how do you prioritize who gets the attorney?
I hate this question.
I'm sorry.
But no, it's we meet once a week. I meet our LOP attorney, who's actually here. We meet once a week to go through all of the people that she's met with potential relief. We will only help if there is potential relief because we have very limited resources. And we really try and only place people on our list, our waiting list as we call it, that we know that we can place. So it really just depends on the timing of the case. If it's a time where we have enough resources, where I have enough resources and time in my day to try and place 10 cases, then I'll try and place them all. But we are, like Judge McEwen said, juggling a bunch of different duties, and one of them is fundraising, trying to even keep the program going, and supervising all of these attorneys, getting trainings going for all of these attorneys, and running the LOP program. So it really is about the relief and how urgent a case is. We always, if it's something between this person being deported tomorrow and us stepping in, we're going to try and do what we can. And that's why we do have some funding for us ourselves taking cases. So if it's something that needs to be done, we'll try and get it done.
And then in terms of, is there any way you could guess the percentage of people who might be eligible for relief who aren't able to get an attorney?
Aren't able to get an attorney? No, I can't even guess. Yeah.
I know it's 80%, it's between 70 and 80% of the population at Mira Loma were unrepresented. And if you look at the breakdown of applications, like most people with representation are LPR, lawful permanent residents, who are applying for cancellation because those are the easiest cases. And then as you go down the line, it gets less and less and less. And then when you get to voluntary departure only, which are your people who really don't have relief, it's something like 9% of the people have attorneys. So it just depends on the form of relief. The location of the detention center, obviously you're going to have more people represented maybe in Orange County as opposed to Lancaster or Adelanto, because attorneys just aren't willing to go out there. And then I also do pro bono placement for our organization, and it really depends on how sympathetic the client is and how winnable the case is. Pro bonos want to win their cases. You know, they want to feel good about helping somebody that they like. And unfortunately, a lot of the people we see are not, maybe I want to, you know, they all deserve quality legal representation, but it's really hard to get, you know, people to help people with sex crimes or domestic violence, things like that. I mean, a lot of advocates are victim oriented. So they just won't take cases of people with, you know, the uglier criminal convictions. So.
And you also have to think when you're placing a case, if this case blows up and something goes wrong with the pro bono, you have to be willing to take it back into your organization. So lots of factors that go into that decision.
So I wanted to just ask you all a little bit, I know you've thought about these issues a lot, and we've talked about some of the short-term issues of trying to get more resources for representation, how to do that pro bono, in-house. All of that requires funding, and there's not really government funding except for LOPs in general. And you know, so a need for private dollars, foundations, et cetera, or something. And then on the longer term, the right to counsel issue, you know, trying to really, I guess, shift the mindset of the public, policymakers, the bar, getting more attention to the issue in general. I wonder, you know, what you all would think of in terms of who are additional allies that we need to really bring into this discussion more? Who can, you know, who can be helpful in this? The ABA has played a fairly significant role in the past, and I think will continue to. But I'd be curious, you know, from the folks working on this issue, but also Marcellus, you know, you've got a broader legal view, and Judge McEwen, you've been thinking about these issues for a long time. You know, if you were going to sort of advise us of, you know, who do we need as champions on this fight, you know, short term and long term, you know, who should we be reaching out to?
You know, I'll be honest with you. One of the reasons why I wanted to be on this panel is because, you know, I obviously don't do this sort of work. And when I got the materials from Ruth and I started reading it, I mean, it was a sea change in terms of thinking about this issue. I mean, there are so many different issues and so many different problems. And being in the world also of being on a lot of different boards, one of the things that I was thinking about as you were speaking was to have a champion with high visibility. You know, you were talking about perhaps, you know, I don't know if it's sociological or think tank models or other people that may bring a different type of discipline to, you know, studying the issue and coming up with solutions. But certainly another way to get traction in terms of changing public perception about it, possibly influencing people, if you had people that were celebrities that, you know, come to these various events, you know, like Public Counsel, for example, other organizations that I'm a member of, they all have this ability to bring in really large names. And then once that happens, these people often have incredibly influential friends. And if there's a given issue that is on their radar, then you see, I think, in a relationship between public interest and somehow all of a sudden that miraculously cures the funding issue, because a lot of these people have significant amounts of disposable income and they want to devote it to a cause. So, in addition to thinking about sort of conservative or in-the-box thinking on this, I think, quite frankly, many people in the society, even lawyers, are not even aware of the depth of this issue and the breadth of the problems. And doing that to sort of spark the dialogue and educate people, I think would be tremendously important. Your Honor?
We've been accused of overstepping our bounds in the Ninth Circuit. I'm not going to do that. So hold my tongue.
Well, just building on what you were saying, Angelina Jolie started the Kids in Need of Defense Fund, and that was when the government was not providing any funds for direct representation of children, and that organization was really the first one to provide representation to large numbers of detained kids. And since that momentum started, that's when the government did start to provide funding for direct representation. So that's a good example of a really recent phenomenon of that. And if we could get more celebrities to care about adults in detention, that would be great. But unfortunately, like I said, a lot of them are there for not the sexiest reasons, and so it's not cute. It's not cute like kids in detention. So it's a little harder to get that sort of big name celebrity push behind it. I think a lot of it's about due process, and that's just not. It's hard to put that into a soundbite. So.
But it's easy to put into 8 hours.
Thank you.